Hey everyone, and welcome to the Wrongfully Heard podcast. This is the Wrongfully Heard podcast.
And wrongfully convicted.
In this case, nobody got justice.
Was wrongly convicted of a miscarriage of justice. Jury found new scientific evidence proving her innocence.
Hi everyone, and if you are new, I am your host Kaylee, and here on the Wrongfully Heard podcast, we talk about stories of people who have not been heard before, which is people who have been wrongfully convicted. Wrongfully convicted means someone who has either been charged or accused or spent time in jail for a crime that they did not commit. In today's episode, we are not going to be talking about a specific case. We are more talking about a role in the criminal justice system that is used to protect justice, but can sometimes have the same issues and fall through the cracks. It is the prosecutorial role. And so we are going to be talking about prosecutorial misconduct. So before we get into that, I just want to put up all the timestamps of what we're going to be talking about in today's episode, just so you can skip through. And yeah. Before we can understand what prosecutorial misconduct is, we need to look more into the prosecutor role and actually understand what they do. In Australia, the prosecution represents the state. They don't represent the victim, they don't represent the accused, they don't represent a specific political party or the police, they represent the state. At the federal level, prosecutions are conducted by the Commonwealth Director of Public Prosecutions, referred to as the CDPP. Their role is to act on behalf of the Australian community and protect Commonwealth law. It is important to understand something crucial. Prosecutors do not investigate crimes. That responsibility lies within the Australian Federal Police or the state police in the area. Instead, prosecutors decide whether a case is strong enough to go to court. They determine what charges should be laid. They assess evidence, draft changes, they appear in court, and they work with police on advising legal issues. While the prosecutors do work with victims and witnesses, they do not represent them personally. Their duty is to represent the public interest. This distinction is crucial. The two-stage test: when should a case be prosecuted? All prosecutorial decisions are guided by the prosecution policy of the Commonwealth. This policy requires a strict two-stage test before a prosecution can commence or continue a case. Stage 1 is there sufficient evidence? The prosecutor must be satisfied that it is a prima facie case, meaning evidence capable of providing each legal element of the offence, and that there is reasonable prospect of conviction. This involves assessing witness availability, witness competence and credibility, the likely impression witnesses will have on a jury, and the admissibility of confessions or other evidence. If there is not enough evidence or the evidence cannot reasonably sustain a conviction, the prosecution should not proceed with the case. Stage 2, is it in the public interest? Even if there is sufficient evidence, the prosecutor must then determine whether prosecution is in the public interest. Factors include whether the evidence is serious or trivial, aggravating or mitigating circumstances, the age, mental health, intelligence or vulnerability of the accused, victim or witnesses, the accused background and prior history, the passage of time since the offence, alternatives to prosecution, the need for deterrence, the attitude of the victim, and the likely outcome if guilt is established. Importantly, the decision must be impartial. It must not be influenced by race, age, religion, sex, national origin, or political advantage. Prosecutors are legally bound and ethically bound to act as ministers of justice, not just advocates for the victim. They need to be advocates for the victim and defense in order to establish the public interest test. Seeking a victory is not the way a prosecutor should aim to do their job. But sometimes this duty fails. So what is prosecutorial misconduct? Prosecutorial misconduct is when a prosecutor abandons their duty to uphold justice and fairness and engages in behavior that undermines justice. Examples include coaching witnesses, relying improperly on indemnified witnesses, withholding exculpatory evidence, mishandling evidence, misrepresenting facts, and selectively presenting evidence. At its core, prosecutorial misconduct happens when the pursuit of justice is replaced with the desire to win. And when that shift happens, the consequences can be devastating. At its core, prosecutorial misconduct is when the pursuit of justice is compromised by the desire to win. And when this shift happens, the consequences can be devastating. Why does prosecutorial misconduct occur? So there are two major psychological and institutional factors that contribute to misconduct. First of all, we have tunnel vision. So tunnel vision occurs when the prosecutor becomes convinced that the accused is guilty. So the suspect is targeted way early on in the case. Once this belief is formed, conflicting evidence can be discounted, minimized, or rationalized away. Instead of asking, is this person guilty? The mindset shifts to, how do we prove this person is guilty? This cognitive bias distorts judgment and weakens objectivity. The scorekeeping mentality. The second point is the scorekeeping mentality. In some legal cultures, success is measured by conviction rates. So a good prosecutor becomes someone who wins more cases. This scorekeeping mentality turns justice into a competition. When a legal firm's culture defines success as winning cases, ethical boundaries can erode. Losses may need to be reported. Careers may depend on performance statistics. Public image may hinge on conviction rates. The prosecutor's role suddenly shifts from a minister of justice to a competitor. Achievement pressure. Achievement pressure is one of the most powerful drivers of prosecutorial misconduct. It includes internal pressure to succeed, organizational expectations, media scrutiny, public demand for accountability, and political sensitivity in high-profile cases. Media coverage can amplify this pressure. Criminal cases are often seen as good versus evil, prosecution versus defense. Public expectation builds around conviction. If a prosecutor fails to secure a conviction on a high-profile case, backlash can occur. Career progression, professional reputation, and public trust may feel at stake. Under this pressure, success can be distorted. Instead of asking, is justice being served? The question that's changed is, will we win? And research supports this connection. Studies show that legal professionals experiencing performance pressure are statistically more likely to engage in unethical behavior, particularly when success is perceived as essential to reputation and advancement, and that success is winning cases. Achievement pressure reshapes priorities. When performance metrics overshadow ethical obligations, misconduct becomes more likely. The link to wrongful conviction. The consequences are not theoretical. In the United States, reviews of DNA exoneration cases have identified prosecutorial misconduct as a contributing factor in approximately 45% of wrongful convictions examined. In an analysis, 381 murder convictions overturned due to police or prosecutorial misconduct. Disciplinary action against prosecutors were rare. In Australia, a national repository documented 71 known wrongful convictions since 1922. Each one represents a systemic failure. Each one represents a life altered permanently. In many of these cases, misconduct was not dramatic or obvious. Sometimes it was subtle. A piece of evidence not disclosed, a witness framed as more reliable than what they were, a narrative shaped too confidently, and a doubt that was dismissed too quickly. As juries are not legal professionals, they do really rely on how the prosecution shapes and forms questions and the narrative around the story and around the prosecution's case. So if that presentation is distorted, even slightly, it can profoundly influence the verdict. The ethical obligation. Prosecutors are ethically required to release exculpatory evidence. They must present the case fairly. They must seek justice, not victory. When those duties are compromised, the justice system is at risk. Public trust erodes, wrongful convictions increase, and the system begins to prioritize winning over justice. Justice is not measured in conviction rates. It is measured by fairness, transparency, and the truth. We have seen this in many of the cases that have been presented already on the Wrongfully Heard podcast. First of all, we had the exonerated 5. Linda Fairstein was engaging in prosecutorial misconduct. Go check out that video if you want to hear more about that. We had Lindy Chamberlain, whose narrative was shaped around being a cold-blooded killer because she didn't display the emotions that one would expect a mother to display. We have Scott Ostick's case, where the prosecution withheld evidence in those photos between the police investigation from the first photo to the second photo where evidence was planted. It was not only the police who engaged in misconduct, it was also the prosecution. And next week we're going to be focusing on Andrew Mallard's case, which is rooted in prosecutorial misconduct. One solution that I believe would be a great push in order to restrict and prevent more prosecutorial misconduct from happening in the future would be to have some kind of legal accountability towards prosecution. Because right now in Australia, in the United States, they have a protection over them. It's called advocates immunity. Because they're advocating for the state, they have this like shield around them from being prosecuted for what they are doing to an extent that I think there's only been one prosecutor who has been actually jailed for prosecutorial misconduct in the United States. So I believe if we loosen the immunity and protect them in some aspects, because prosecutors do deserve to be protected in some ways, not fully give them that full immunity would be a great way of preventing this from happening in the future. All right, this is the end of the episode. I hope you all learned something and enjoyed this episode. Let me know if you kind of like this kind of video more than when I just focus on case by case, or would you rather me talk about certain issues, prosecutorial misconduct, or I can talk about police misconduct, or investigative malpractice, or stuff like that. Let me know what you want to see next. We're going to be covering the Andrew Mallard case, as I said before, in our next episode, which is a really, really tragic case of wrongful conviction. So I hope you enjoyed that one as well. Stay tuned, because we are going to be posting more on TikTok, on Instagram, on YouTube. So yeah, thank you everyone for your support on everything so far. I really appreciate everyone commenting and expressing their opinion and being very respectful in the comment section, and just like advocating for a really important issue that I feel gets lost in the media these days, because there are so many things going around in the world. And I think if we keep this in the forefront of people's mind, there will be less injustices happening in the future. So thank you everyone for watching the Wrongfully Heard podcast, where we give voices to those who were not once heard. And I will see you all in the next video. Bye everyone.